Long-term disability policyholders claim for benefits denied on the basis that the policyholder was not actively employed at the time of filing the disability claim because of his reduced hours. In my opinion, one of the most dangerous periods of time for an LTD policyholder is the period immediately before they apply for disability benefits, because reducing hours can lead to an argument that the disabled policyholder is not actively at work when they apply for their benefits. So the practical result is, if you reduce your hours so that you're not working the correct number of hours per week required to maintain your coverage, the carrier is going to deny your claim despite the policyholder's effort to continue to work. Now, while you're working, the carrier will say that it doesn't meet the active at work requirements of the policy. And worse yet, I think, is a situation in which the disabled policyholder reduces their hours and then is paid their full salary while working their reduced hours. Now, when you apply for your benefits, or if you were terminated by your employer, the carrier is going to deny the claim on the basis that you weren't actively at work while being paid their full salary, or alternatively, that they just weren't disabled at the time they were terminated because they were paid their full salary. It's a gotcha either way. So I want you to consider the case of poor Mr. Boyles. I read the cases across the United States and I learn lots of lessons, and I'll tell you the lesson we learned in the Boyles case. He had undergone 4 spinal surgeries, and he told his employer in December 2012 he was going to apply for his benefits. His employer made him an offer he should have refused. So let's talk about that, because in this case, the Pennsylvania court didn't do him any favors, and neither did his employer. The employer had offered to pay Mr. Boyles his full salary, but they didn't tell him or discuss whether he should pursue a disability claim with Allstate, who was the LTD carrier. Boyles continued to work in a limited capacity, and he collected his full pay. Then the employer changed carriers from Allstate to Unum on August 1st, 2013. On November 22, 2013, the employer discontinued the full payment of his salary, and as a result, Boyles then filed a disability insurance claim against Allstate, who denied the claim on the basis that since he was collecting his full pay, he didn't meet the policy definition of disability. He also filed a claim against Unum, and Unum denied the claim on the basis that Boyles was not in active employment on August 1st, 2013. He wasn't working the required number of hours to be covered under the Unum policy. So Boyles sued his employer and the owner of the business for a breach of fiduciary duty because they had failed to tell him his rights when the owner gave Boyles the option of paying his full salary instead of filing for disability benefits, and what could happen when there was a change in insurance carriers. Unfortunately, the court found that the owner didn't make any misrepresentation to Boyle when he made the full salary offer, and that Boyles didn't have the ability to sue the carrier for this misrepresentation. So Boyle lost out. The lesson learned is that before you reduce your hours because of disability, get out your policy and read it. Before you accept an employer's offer to pay full salary, get a copy of your policy and read it cover to cover, so you know what the term active employment means. You know the right day to claim disability benefits, and you know the right day to stop work and apply for your benefits. Better yet, contact me at 727-894-3188 to learn more about your rights to your disability benefits and what the term active at work means in your disability policy.